So it's worth pointing out here the employer responsibility, because this goes both ways. If you are responsible for your employee who takes something, you do get the advantage of if your employee finds something, then it's yours. So it goes both ways. What about the jewel? The fact that the jewel was found in a private home. I think it was found in the chimney. And at this point, there weren't any rules, common law rules, dealing with that topic, though they are developed over the course of time. So we move on to Bridges versus Hawksworth and the money packet. So there was a packet containing money found on the floor of a shop by a traveling salesman who had entered the shop. He showed the packet to the shop owner, and it was decided that the box would be left, or that the box was left there unintentionally by an unknown person. So the finder left it with the shop owner, who put adverts in the newspaper, and after 3 years, he asked the finder if he could keep the money packet, and the finder said, "No, I want it back." So, how do you claim possessory rights here? Now, if we just look at the rule from before, the finder, gets better rights than everyone but the original owner. It's quite easy to decide. He found that there was a clear act. The mens rea was when he gave it to him to find the original owner, and then said, "No, I want it back," when it wasn't found. So the only issue here really is it was found in the shop owner's store. But the judges determined that the notes were never actually in the custody of the defendant, nor in the protection of his house. They mentioned that what if the object had been kicked on the street before the shop owner found it? Would he have any rights? So if something happens to be in your public store and it gets, it's not yours, and it gets kicked out, do you still have any rights over that object? No, you don't. And so there is no significance in the location of the object, and the plaintiff in this case wins. Had it been intentionally deposited in the shop, and the defendant knew it was deposited there, then he could exercise some rights. So Bridges and Hawksworth, additional point, when Hawksworth gave the packet to Bridges, he was not waiving his possessory rights. I like that point. Moving on to Ewells and Briggs. Briggs is a gas company. The facts are that they found a dugout boat. So Ewells owns a property. He's lord of the manor by lease for life. It was a settlement where someone else gave him the right to hold the land for their life, and then it would pass on to the eldest son of the rightful owner. It's called a fee tail. Anyway, so the occupier could not sell it, but this life estate trumps any leasee. So Ewells leases the land to the Briggs Gas Company for 99 years to erect gas holding tanks. According to the lease, mines and minerals are reserved for the leaser. And Ewells had to approve structures, and at the end of the lease, Briggs could take out their trade fixtures. So as the company was excavating to build a structure, they found a large dugout boat. Is the boat a mineral? Is it soil? Is it a fixture? Or is it a chattel? So if it's a mineral, soil, or fixture, it's Ewells. But if it's a chattel, in other words, just a found object, it could be Briggs, and presumably this is according to Armory and Delamere. We still don't have any rules regarding manifest contention and private property. So if it's just an object found on the property and you aren't trespassing to get there, and you find it, then and it's not attached, then it's yours. So if it is a chattel, it could be Briggs's. Now the decision was that it was attached. So, and according to the contract, because the contract didn't specifically say that, if you find a boat underground, then, it's still mine, they decided that there was no implied consent. So just because the contract didn't mention it, it doesn't imply that there's consent to take it. And it also makes no difference that Yules didn't know it was there. So here we see that if it's been deliberately left by the owner, occupier, or if it's attached, then it's the occupier owner has a possessory right, and the finder must establish a possessory right that is antecedent prior to the owner-occupier's right. What they decided was that if it's under the soil, then it's attached. So if you have to interfere with the land to get it, then it's attached. So, and that's kind of an interesting rule. So if you have permission to be somewhere and you have to dig the soil in order to get at something, then it's the object that you found is attached. But we still don't have possessory rights for loose objects on private property. So Yules and Briggs establishes that things that are underground are attached and the owner has the possessory rights. In this case, though, they also cite Reg versus Roe. There was iron at the bottom of a canal. They drained the canal and someone took the iron. And it was decided that if it's underwater, it's attached, and they used that to decide that if the boat is under the soil, it's attached. So South Staffordshire Water Company versus Sharman Two Gold Rings. Here, the water company owned a piece of land, and they were cleaning out a pool with workers they had hired. One of the workers found 2 golden rings and gave them to the police. The real owner could not be found, and the rings were given back to the defendant, so the employee that found the rings. The water company sued them for the rings. Now, the decision was that possession of the land carries with it possession of everything that is attached to it or under the land. So being that they were in the mud, they were attached to it. And this is unless there's public invitation. So here in this decision, the judge starts talking about the difference between public invitation and private property. So he in the decision, he keeps going and he starts to create a precedent. She stated Lord Denning in class, but I think it's Chitty, but nevertheless. And it seems like Cullowen in the following case. No, this is Cullowen. Cullowen in South Staffordshire. Now maybe Lord Denning was also speaking, and I didn't actually get to read the full case. So anyway, she says that Lord Denning adds the public versus private distinction. And this solves the chimney case where the person who owns the house would own the jewel-encrusted object. So now we're starting to talk about the necessary acts and the necessary intention, and the assumption that if it's on private property, then there is the intention to keep it. So we're starting to develop what's known as manifest intention, where because it's your property, it is manifested that you have an intention to keep the object. So moving on to Hannah versus Peel and the brooch. There was a house given to the defendant, but he never lived there. It was requisitioned by the government, and the plaintiff Hannah moved in as a member of the armed forces. He was putting up blackout curtains and found a brooch loose on the sill. It wasn't deliberately placed there, and it's loose. So he gives it to the police, and the police give it back to the defendant because it's his house. So they give it to the person that was the owner of the house, not the person that found it. So what do? The person who found it, the plaintiff, sues and says that he owns the brooch. Now, the defendant isn't going to argue attachment because it was loose, it was a loose brooch. So they argue South Staffordshire, where the rings were found in the mud, and they developed, the doctrine of manifest intention. On a side note, South Staffordshire, they also could have argued kind of employer-employee rule where what the employee finds while they're working belongs to the employer. But they argued manifest intention. Unfortunately for the defendant, the court read down the South Staffordshire decision and said that they had erred. That was really a case of attachment and employment. And that because he had never actually lived in the house, he hadn't performed the proper actus reus, mens reus, in order to establish his possessory right. And the plaintiff, the finder, got the brooch. City of London. So the City of London has allowed someone to build a building. As the workers are breaking down the walls, they find a safe. They assume the safe has value, and the court finds for the occupier. The person that finds it is an employee. So safes are generally deliberately put in a place, and so they determine that it was attached, and the safe belongs to the property owner. So regarding things which may be upon or in it attached, the presumption is that the person who has possession of the house has manifest intention to exercise control over it. So here we're not, we're moving further and further from underwater and underground and attached to things that are in the building. And if it's in the building, we've got the proper mens rea due to manifest tension. So Grafstein versus Holman Freeman, there's a box of money, there's a locked box found in an employee, buying employee in a dry goods store. He brings it to the owner says put it on the shelf. 2 years later they open it up and find $38,000. The decision is that you can't determine who has the possessory right to the money until the box is opened and it belongs to the employer. This has to do with the employee-employer relationship as well, but Lord Russell decides he relies on manifest intention. The owner took possession of the box when it was first shown to him, and it was in his possession when the box was opened. So, and the point here is that you should bring as much to the case as you can, as many arguments and as much arsenal as you've got. Brings us to the final case, the lengthy case in the casebook, Parker versus British Airways Board, and it's regarding a bracelet. A person finds a bracelet in the executive lounge at the airport. He brings it to the desk and leaves a contact information, mens rea, asking for the bracelet if the owner isn't found. The owner isn't found, but the bracelet is sold and Parker sues for profits and interests. He's given £850 and £50 interest. So, what arguments would he have to make in order to get to establish his possessory rights? There's obviously an actus reus and a mens reus, but does the British Airways, can they establish a possessory right for prior to Parker's? And the only way that they could do that is through manifest intention. However, the judges decided that it was too much of a gray area. It was too public to provide manifest intention for unattached objects. So the fact that the public could get in and out, even though it was restricted to only certain members of the public, meant that the application of manifest intention didn't apply. So the points here are basically that the finder's cases are really difficult to figure out who's going to win, because all you have is common law, and if you lose it all, and it's the exact same approach when it's $1 million. So if you can settle, that's a good idea. And with regards to being a law student trying to figure this out, you need to let go of being right. You're only right when the last court has found in your favor. So our job is just to argue as best we can, and what matters most is bringing every bit of arsenal that you can to the game. So no matter what evidence you can find to support your client, you gotta bring it all, as much as you got. With regards to figuring that out, it's very important, and this is a very key point. We don't just need to know what is said in the case, we need to know who said it and why they said it. So the judgments that are coming out, we need to know who that person is and why they're saying what they're saying, which is an incredibly high level of detail. That's what I learned in property this week.